Oh my, Melania Trump is rushing to federal court over an Epstein files claim.
Melania Trump is threatening to sue Hunter Biden unless he retracts comments he made in a recent YouTube interview alleging that Jeffrey Epstein introduced the First Lady to her husband, President Trump.
Before we go any further, before you scroll away or click on another video, there is something critical you need to understand about what is unfolding right now. Because this is no longer just a YouTube interview moment. It's no longer social media chatter. And it's definitely not just another celebrity legal threat meant to grab headlines and disappear. What we are watching take shape has the potential to become a serious nightmare scenario for the Trump political universe. Not because of what was said in one interview, but because of what could be forced into the open if this escalates any further. Melania Trump, the former First Lady of the United States, is now threatening a $1 billion lawsuit against Hunter Biden. And the reason behind this threat revolves around a name that still sends shockwaves through elite political and financial circles years after his death. Jeffrey Epstein. That is the moment where this story stops sounding like gossip and starts looking like a dangerous collision between power, law, reputation management, and long-buried questions that some very powerful people would prefer remain unanswered. To understand why this matters so much, we need to slow down and be precise about what was actually said, and just as importantly, what was not said. Hunter Biden did not leak documents. He did not claim inside knowledge. He did not present any allegation as a proven fact. What he did was far more limited and far more legally careful. He referenced reporting by journalist Michael Wolff, stating that Wolff had publicly claimed Jeffrey Epstein introduced Donald Trump and Melania. That was it. A reference, an attribution, a citation of existing journalism that has already been published, discussed, and debated. And yet that single reference appears to have triggered something close to full panic mode. That reaction alone should make people pause. Because if a claim is meaningless, if it is obviously false, if it carries no real weight, then why does it provoke such an extreme response? Why threaten a billion-dollar lawsuit instead of calmly dismissing it? Why escalate at all? This is where legal reality becomes impossible to ignore. Defamation law in the United States is not about hurt feelings or embarrassment. It is about provable false statements, measurable harm, and intent. To win a defamation case, especially as a public figure, Melania Trump would need to prove several things simultaneously. That the statement was false, that it caused real damage to her reputation, and that Hunter Biden knowingly or recklessly spread false information. And this is where the entire legal threat begins to wobble. Hunter Biden did not present the claim as his own. He did not assert it as fact. He clearly attributed it to a journalist who has made that claim publicly and repeatedly. That distinction matters more than almost anything else in defamation law. There is a massive legal difference between inventing an allegation and accurately referencing existing reporting. Michael Wolff has made this claim on the record. He has stood by it. He has not retracted it. And he has not been successfully sued over it. That means Hunter Biden did not fabricate anything. He referenced journalism that already exists. And referencing existing reporting is, in most cases, legally protected speech. But the most dangerous part of this entire situation has nothing to do with who said what in an interview. It has everything to do with what happens next if this threat turns into an actual lawsuit. Because lawsuits don't begin with dramatic courtroom speeches. They begin with discovery. And discovery is where control is lost. Discovery is the legal phase where both sides are allowed to demand evidence. Emails, messages, photographs, travel records, contracts, witness lists, depositions under oath, timelines, third-party communications, documents that were never meant for public view. And once discovery begins, one question becomes unavoidable, and unavoidable questions are the ones powerful people fear the most. How did Donald Trump and Melania Trump actually meet? That question has never been examined under oath. It has never been dissected in a courtroom with lawyers demanding documentation and sworn testimony. And once that door opens, it cannot be closed again. This is why legal experts often warn that defamation lawsuits are among the most dangerous lawsuits a powerful person can file. Because once discovery starts, you no longer get to manage the narrative. You no longer get to decide what is relevant. The process decides for you. If this claim is harmless and false, why risk opening that door at all? Because discovery does not deal in stories. It deals in records. And once records enter the legal system, they don't disappear. They become permanent. At that point, this stops being about Hunter Biden. It stops being about one interview. It becomes a stress test for the Trump brand itself. There is another layer to this that makes the situation even more revealing. If this claim is truly defamatory, why not sue the journalist who originally made it? Why not sue the media outlets that reported it? Why not sue the commentators who analyzed it? Why focus almost exclusively on Hunter Biden? Because this threat does not appear to be purely legal. It is political. Hunter Biden's name is radioactive. It is designed to send a message not just to him, but to everyone else watching. The message is simple. Touch this topic, and it could cost you everything. That is also why the timing matters so much. Jeffrey Epstein is re-entering public discussion. Donald Trump is under legal pressure on multiple fronts. Another election cycle is approaching, and public memory is being reactivated. This lawsuit threat looks less like a serious attempt to win in court and more like an attempt to contain a narrative before it spreads further. It's a familiar strategy. Threaten aggressively, demand retractions, signal overwhelming legal firepower, hope the other side backs down. But then, something unexpected happens. Hunter Biden does not apologize. There is no retraction. There is no takedown. He essentially says this isn't happening. And that is the moment where these kinds of legal threats often collapse, because once the other side refuses to fold, escalation becomes incredibly risky. Donald Trump's response to all of this is also revealing. He reportedly says he told Melania to go ahead with it. That is not a legal argument. That is a power signal. The subtext is clear. We sue people. People usually give up. But the real question is what happens when someone doesn't. Ironically, this situation may pose far more risk to the Trump family than it does to Hunter Biden. Because in defamation law, the strongest defense is truth. And truth is not a single sentence. It is context, timelines, relationships, patterns, and corroboration. Once those elements enter the legal record, they cannot be erased. This is why Jeffrey Epstein's name still detonates politically. He was not just an individual, he was a connector, a facilitator, a bridge between elite worlds. Every time his name resurfaces, the same question follows close behind. Who else knew, and how much did they know? That is why this issue is so sensitive. Not because of one alleged introduction, but because of what that introduction represents. And this is where the story becomes even more complicated. Journalist Michael Wolff, whose reporting was referenced, has not backed down. He has publicly stood by his claims. And instead of quietly retreating under the weight of legal threats, he has made it clear that he is prepared to defend his reporting. That matters, because it introduces a second front in this situation. If a journalist with sources, documentation, and first-hand knowledge refuses to retreat, the risk calculation changes dramatically. At that point, the threat of discovery becomes real, not hypothetical. Because discovery would not stop at one question. It would expand. It would ask about timelines, social circles, travel, events, introductions, and the broader context surrounding them. And once sworn testimony begins, inconsistencies become liabilities. This is why legal escalation often stops at the threat stage. Because everyone involved understands that the courtroom is not a place where narratives thrive. Evidence does. So where does this go next? There are only a few realistic outcomes. The threat quietly fades away. A lawsuit is filed and quickly settled. Or discovery begins. And the third option is the most dangerous of all. Because once discovery starts, control is lost. This is not a story about Hunter Biden. It is a story about what happens when power collides with law. About what happens when influential people attempt to control history instead of confront it. Sometimes, history pushes back. The real question now is not whether a lawsuit will be filed. The real question is what doors it would force open if it is. And what happens if Jeffrey Epstein stops being a rumor and becomes evidence? Because this story is not ending here. It is only just beginning.